SJC-11855, Commonwealth v. David J. Kaeppeler.
Good morning, Mr. Sheketoff. Why don't you wait a moment? And I guess, Ms. Haller, is this your last argument before us?
I think it's my last.
Retiring so young.
I have one more in the appeals court in October, and my husband and I, our son's in college, and we're going south because I don't want another.
All right, well, congratulations. Congratulations. Some of us have gone south long ago, although we're still here. So, okay, good morning, Mr. Sheketoff.
Good morning, Your Honor. I wish I only cried once after arguing in this court. I do want to talk about of course, the parties have no idea why you took this case from the appeals court. But I want to spend most of my argument on the...
Oh, because of you.
Oh, yeah. I do want to spend most of my argument on the search and seizure issue, but since Bowdoin was my case some 35 years ago or so, I do want to make a few comments about Bowdoin. There aren't that many defenses that defendants can raise. Bowdoin is one of them. It's a very common defense. This court has recognized it over 35 years ago as a defense. And yet our case law is that it's totally up to the judge's discretion to decide whether to give a Bowdoin instruction. That makes no sense to me. And each defendant at the bar should have the same rational instructions to the jury that any other defendant has at the bar. For instance, in this case, a very experienced trial judge said, sometimes I give it, sometimes I don't. If you believe in rational jury finding, it seems to me any theory of defense that is justified by the evidence, the jury should be told about, whether it's misidentification, alibi, Bowdoin, or any other such issue. The United States Supreme Court has said that a defendant is entitled to a theory of defense instruction, and you should change your case law on this to promote more rational jury finding and equal protection to defendants that are before the bar. Now,
before you leave that issue, the Bowdoin instruction, which I guess is on page 30 of the brief, which was proposed, came from where? Is that a model instruction in any fashion?
It comes from the case itself. It's language lifted from the Bowdoin case, for the most part. I didn't draft that instruction.
Okay, it's not the easiest concept to instruct upon.
No, but either is misidentification, and many of these theories of defense are actually subsumed in the standard charge. You got to prove that the person was the perpetrator. Why would you have to explain misidentification? You have to prove that the defendant was there committing the crime. Why would you have to, have an alibi instruction? Because that's the theory of defense, and the jury's entitled to hear the defendant's position from the judge, that this is a legitimate theory of defense, not just from the lawyer in argument, because argument is hyperbole. All right, so the search and seizure issue. It seems clear from the facts in this case that the police had an objectively reasonable reason to go to the defendant's home and knock on the door and do a well-being check to see if he was sick or injured in some fashion, like the two people who were at the hospital that had spent the night at his home.
It was actually the hospital that suggested it, right? I mean, that mentioned that he was still there?
Yes. I think that's a fair inference from the testimony that the dispatcher at the police station had heard something from the hospital. So they go to the house and they knock on the door and he answers. And they convince him to go to the hospital. He invites them in. They have a chit-chat with him. And when he's gone, they decide to call a criminal investigator from the sheriff's department, because these are local Barnstable police officers, and to photograph and then seize the 2 Patron tequila bottles that they had seen in the house. So,
But one was in the garage?
correct.
He had already gone to the hospital at the time they went into the garage?
I think the record is that
Aren't they
they
asking
opened the
him
door
questions?
to the garage while he was still in the house and saw the bottle there, but they photographed it and seized it after he left.
But were they escorting him through the garage to go to the hospital?
I don't think so.
He told them that it was in the garage. He said, I think,
Right,
they asked, and he said, I think there's another bottle out in the garage.
right. And they opened the door and looked and saw that there was another bottle in the garage on top of the recycle bin. My first line of defense, so to speak, is that this exception, this emergency exception, was over when he answered the door and he left to go to the hospital. The exception is narrowly drawn. It only permits a sweep of the house to find if there's anyone injured or in need of aid. It doesn't permit going through drawers or anything of that nature. This quote-unquote emergency was over as soon as he left for the hospital. And they had to vacate the premises. Of course, they could have said to him, is it all right if we take these bottles? They could have sought consent if they were concerned that somehow or other these bottles were very important. But they didn't bother to do that. They actually waited till he left.
Is it unreasonable for the police to seize items that are logically connected to a condition for which the emergency response was appropriately made? In other words, isn't it reasonable to assume that, well, I think they had learned that the people had ingested something that made them very ill.
I'm not sure that that's correct. They knew that people were ill. And
they
so
didn't
they're
know
trying
why,
to figure out.
And they didn't know why, right?
They didn't know why. So
And he said that he was sick. So are you suggesting just before that, is it reasonable to inquire about what the individual who might also be as sick as the other very ill people had ingested that might be common to all 3? Is that reasonable to inquire?
sure, they could have asked him anything. He's not in custody. They could ask him any question they wanted. They did ask him a number of questions, including whether or not he knew what the drug that obviously the sergeant suspected was involved, whether he knew about that drug. And if they had probable cause to believe that some crime had been committed, they could have seized those bottles if they had a belief that it was logically connected to a crime. They could have seized those bottles. The question is, they're in that house to do, at most, a protective sweep. That's my first line of defense. And you would have to expand this exception to include things like an investigation for what potentially could have caused the problem. And there is a case like that in the appeals court called McCarthy, where it's not a home case, but a woman is at a bar and she's passed out, and the police are called, and they come, and the police officer calls the EMTs, and the EMTs look at her and they say, you know, we think this is a drug overdose of some sort, and do you know what caused it? And the police officer looks into her pocketbook, which is on the floor open near her, and finds some cocaine, and shares that information with the EMTs, and that's the farthest anyone's gone.
So are you suggesting that that's a plain view thing? I mean, that's governed by plain view doctrine?
No, I'm suggesting that that if you don't buy my first argument, at least that was objectively reasonable. Because my second argument is, I would say that was an appeals court decision. I would say that they're wrong. He couldn't go into that purse unless they had put out more facts, which I can't tell from the opinion, that it was open, he could see vials in there and things like that. My first line of defense would be, you can't do that. If this is an emergency, namely you're rendering aid to the person, you can't conduct any kind of search other than a sweep. Certainly in the home, maybe in a bar it might be slightly different.
Let me stop you there. I'll let you get to your second, if this may lead to what I think is your second, since I know you well. Let's just, here, of course, there was no forced entry. So
Correct.
You don't need the emergency exception to get in. They knock on the door, he answers the door, they speak with them, he invites them in. There's no, but imagine they knock on the door, there was no answer, you have no problem with them coming in, they see a man sleeping they seem to have difficulty getting up, they see pills laying by him. Is it within the emergency exception for them to take him to the hospital, seize those pills, bring them to the doctor, and say, we found these pills next to him, and this may aid you in your medical care of this individual?
Okay, so that is my second.
That's what I thought, because here I guess that this was never presented to the hospital, is that correct?
Correct. They called a criminal investigator. The judge found that, well, these people he took judicial notice of the fact these people at the sheriff's department do other things. I say that's a fact you can't use because that's an inappropriate fact for judicial notice. But in any event, what they do is call a photographer, he takes a picture, he takes him, he's a custodian of evidence, he takes them into evidence and logs them into the sheriff's department. So, at least in McCarthy, there's a direct correlation between the search and the reason for the exception, which is to aid somebody. In other words, in McCarthy, the EMT actually says to the cop, tell us, what her problem is. And it's clear that if you're talking about objective reasonableness, it's clear that what he did is objectively reasonable to answer that question, which is a legitimate question based on the exception itself. And to me, a lot of this stuff about objective reasonableness, I think about, just as an aside, let's say it was a murder case, and my defense is, well, I acted in self-defense. The person came at me with a gun, and I clubbed the gun out of his hand with a golf club. Now, that's objectively reasonable, what I did, if those facts are true. And I just don't want to look at the next part of it, where then I club him in the head again and again and again and again. I want to just focus on the first part and say, well, that's objectively reasonable, what I did first, ignore the rest of it. So I think I'd have a much more difficult case if these police officers, whether they were right or wrong about their logical connection to the bottles, if they had gone to the hospitals with the bottles, or they had called the hospital about the bottles, or they had called the doctor while they were there and asked, or if they brought them to some lab because they knew about some testing procedure that could be done that would disclose what was in these bottles. In other words, if their actions had something to do with what they were supposedly there for. But instead, they photographed them. What does photographing have to do with rendering emergency aid? That's not objectively reasonable. And what does taking them back to the sheriff's department have to do with emergency aid? So when you step back and take a little bit longer view of what they did, you could say in my manslaughter example that, well, if you just look at the first thing that he did, then we could say that's objectively reasonable. And I think that's true. I think a police officer, I'm not talking about his subjective point of view, because clearly this police officer may have believed right from the beginning, as the judge suggested, he had a hunch that, that a crime had been committed and that this was the means of committing it. He had that hunch. But that doesn't matter. Even if his subjective point of view was, I need an excuse to seize this stuff, If he had done something with it that has something to do with the emergency exception, I don't think we get to look at a subjective state of mind. I think I just plain lose, because objectively what he did was reasonable, and a reasonable police officer would have done that in the circumstances.
Can I just ask you on that theme? Let's say that sort of like the EMT, the hospital had said, you know, we think you should go check, or we suggest you go check because we've got these two people here. We have no idea what's wrong with them. Look around and see if you can find anything that might relate to what's happened to them, and you know, make sure he's fine, but also look around. Do you think that if that, so that's a sort of two-part thing, see if he's fine, but also look for something to help us. Would you say that that would need, the second part would need a search warrant in any event? Or would it be okay for them to do that?
Okay, so in that example, I think you need a search warrant, because if you open up this exception to that, you know, to a suggestion, look anywhere, then you search the whole house. I mean, you could even go onto the computer to see if he's been researching, you know, some kind of a way to kill himself. I don't see anywhere that it stops. You go through the entire house. But let's say it was more like this case, where it's in plain view. Once, you know, because they get to sweep, they see, you know, maybe somebody else was in the house, and it's in plain view. Then I think, no matter what is in their subjective mind, even if they subjectively think this is a criminal investigation, as long as what they do is objectively reasonable to the emergency exception, it's fine. You know, if they called the hospital back and say, it's tequila, you know, and it smells like such and such, or it has a soapy feel to it, or something like that, it seems to me, whatever they're subjectively thinking, they've done what was reasonable. But to just stop it at, oh yeah, a reasonable person might have picked up that tequila bottle, yes, that's true, but to be really a reasonable person, you got to do something with the tequila bottle that makes sense to the emergency exception. You can't just, you know, pack it up and send it to the station for later processing. I'm out of time. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Julia Haller on behalf of the Commonwealth.
So what do you say to that last argument?
He's completely doing it wrong. I'll come right out and say it. If you look at the test...
I'm sorry, he being the police officer, or he being Mr. Sheketov?
Excuse me, Mr. Sheketov,
Okay.
and I say that with great respect for Mr. Sheketov. The test is that the search is not to gather evidence. And if you get past that and you say it's a true emergency, then the next part, you look to the objectively reasonable grounds to believe that an emergency existed, with the caveat that the reasonableness must be evaluated in relation to the scene as it appears to the officers, and not with a retrospective analysis, which is what Mr. Sheketov just did for about 5 minutes. You can't say, well, they didn't do this, they didn't do this. It's when they seize the evidence.
At the time that they seized the tequila bottle, the rationale for seizing the tequila bottle in real time was that it may have something to do with these three people's condition.
Right.
I need to get that to the hospital to help them render emergency aid.
But once you've seized it, you freeze the scene. It doesn't matter. No,
that can't
no,
be.
because it says you can't look at it in a retrospective analysis, and that's what's going on. You have to say when they seized it, they had an objectively reasonable belief. The fact, there's nothing sinister with the fact that he calls an officer to come in and do it right, to do it properly. There's nothing sinister. It doesn't add anything to the fact that this may have been for the collection of evidence. He turns it over to the CIO.
But if it's objectively reasonable, wouldn't the next can't you test that by what he then does with it?
I would say no.
Why?
Because it's when it's seized. It's what's going on. There's an evolving scene. At the time the officer seized it, he turns it over to the CIO. They take the defendant to the hospital.
It seems to me you're confusing it with something like, you know, you go to render aid and then somebody's out and sleeping in a car and you see 3 bags of cocaine on the front seat. I mean, right there in plain view is evidence of a crime. You had the ability to do that. But when they seized the tequila, they didn't seize it because they thought it was evidence of a crime that was in plain view. They seized it because it might have some connection to the emergency for which
Right.
these three people need evidence, need
And that's
treatment.
the analysis. That's the analysis, once it's seized. They had evidence.
Well, maybe we need to change that analysis.
What the police had an evolving situation. They knew from the hospital tells them, if you look at the dispatch note, which is page 16, Officer Tynan mentions that they had two individuals at the hospital for an overdose, and both attended the party in Marston's
Aren't you
Mill.
stopping the picture too soon? It's an evolving situation regarding an emergency. If it's okay to stop and not provide the probable source or possible source for figuring out if it's heroin, and you need a certain kind of anti-heroin injection or not, because if you do the wrong thing, you're going to kill somebody. If you don't do anything at all, you're going to kill somebody. If you're in that kind of situation, oh, we'll just take this drug and do nothing with it. You haven't completed the picture that relates to the emergency. Wouldn't that be another way to look at it?
No, once Tynan turns it over to the CIO, the officer, we don't have anything more about what Tynan does, or what it's now out of his possession. He goes to the hospital. He's there following the scene at the hospital. They've got two people who are being med-flighted. They've got the defendant who doesn't show up at work. It says, oh, well, we all drank the tequila and I haven't been feeling well. And where's the tequila? Oh, here's the tequila. Okay, he takes the tequila. That's the way it ends. I mean, that's all the information that we have.
So I'm kind of curious as to what some of the ramifications are here. Supposing the two people at the hospital died, and it turns out that what was in the tequila bottle, had it gotten to the hospital in time so they could have analyzed it, they would have been able to save the lives of these two people. I mean, is that okay?
No, it's not the analysis. The analysis here is what was reasonable in his mind at the time he seized the tequila bottles.
And what he does with it afterwards can't be applied to that analysis to determine whether he was hypocritical at the time that he seized it?
But he wasn't hypocritical. The judge found that it was based it on a
The dumber
findings of
you
fact.
are, the better off you are?
No, not that at all. It's that at the time he seized the tequila bottles, he had a reasonable belief that there was an emergency going on. Now, we don't know what happened to the tequila. Unfortunately, we do know what happened to the tequila bottle. It wasn't tested, but that's not that officer's fault. He gives it to the CIO.
CIO stands for?
I'm sorry, collections officer, I believe. He was a deputy
Evidence
sheriff.
officer.
Correct. Yeah, I'm drawing a blank on it, sorry. But
But it's given to the evidence officer.
Evidence
It's
officer.
not, but doesn't that speak of it as being treated as evidence?
Not at all. It's like if you give someone Miranda warnings out of an abundance of caution. This is how we collect things. We don't pick them up ourselves. We call in the professionals, if you will, to collect.
But this was not, but the purpose of an emergency exception cannot be investigative.
And it wasn't. The judge made a finding of fact that it was not investigative.
But initially, but it appears after it turns out that he is okay, that,
It wasn't okay.
well, he turned out to be okay, but.
Well, I mean, he wasn't at the time.
But they took the steps appropriate for an emergency with regard to him, and then it seems that that this entry then becomes investigative.
Not at all. The judge made findings of fact contrary to that based on the evidence.
So he converted the evidence that was taken for emergency purposes, he converted it into investigative evidence.
You can't draw that conclusion. We don't know that.
And Officer Tynan didn't convert anything. He just turned it over.
He just turned it over to the CIO because that's what you do. The collection officer now takes custody. And that's what was done. And at the time he seized it, he had the reason. You can't look, it's a Commonwealth's position, you can't really look beyond that because it's at the time of the seizure. This court has said time and again, it's the time of the seizure. They had two. They had one who'd already been med-flighted and was out of the picture. And the other one, I think, was in the process of being med-flighted. And so at that point, you can't speculate as to, how this evidence would have been of help because they were already on their way to Brigham and Women's Hospital to be treated.
It still could have been obviously of help. If they took it to the Cape Cod Hospital, and there is communication between the helicopter, the Boston hospitals, and the Cape Cod Hospital, but they didn't do that.
And you can't look at that part of it. It's at the time of the seizure.
But why, I mean, why can't we? I mean,
Because you can't, because the case law says that
well,
you
I mean,
can't look at the...
it's our case law.
Well,
so
if you want to change it, go right ahead. You can't look at it with a retrospective analysis, the leisured
but it's not
retrospective analysis.
retrospective
But it
because
is.
the police collectively never did what you would hope they would do if it were treating it as an emergency,
And
which
now
is
the defendant is second-guessing.
But we're
what the
talking
purpose
about an
was.
exception.
Right.
We're talking about an exception.
Right.
So usually exceptions need to be somewhat narrow. You would have it go the other way. It's somehow the defendant's burden to show
No,
that
not at all, not at all. I'm not claiming that at all. The Commonwealth has the clear burden to prove that it wasn't to gather evidence. The Commonwealth met this burden through the officer's testimony. The judge made a clear finding of fact. Then we showed that it was an emergency.
I'm sorry. I don't think it's just a question of whether it was to gather evidence. I mean, there are boundaries about the emergency exception to begin with, and that's what we're looking at.
Right, and you have the emergency. You have two people who are very ill. You have a defendant who doesn't show up at work and is very under the influence of something when the police show up. The police are there with a good faith basis to find out what happened to that party the night before, what is the commonality, what is going on. Oh, we all drank tequila. Where's the tequila? It's right here. Did you drink out of another bottle? Yes, we might. This is an evolving scene. Well, this might have been, and they go in and the defendant gestures and he says it's in the garage. The officer goes and opens the garage door, sees the empty bottle, and then he calls, you can infer that he calls the CIO officer while the defendant is still present. The defendant's there.
Ms. Holler, the emergency had nothing to do with the two other people. They're coming into the house to check on the defendant.
Oh, no, the emergency absolutely had to do with the two other people. That's what the dispatch was. From Tynan had the dispatch.
But it was
No,
to
I
check
understand that, but the purpose of going into the house was not to find out what happened to these other two people.
I
The
respectfully
purpose-
disagree.
Well, then,
Tynan's-
what is the law that allows the police to do that?
The police had a dispatch that two individuals were in the hospital for an overdose, and both attended a party at this particular address in Marston's Mills. The police were dispatched at that point to go to see what was going on. Then a second dispatch comes in almost immediately saying, the defendant who lives at that house didn't show up for work, and we're worried about him. So they dovetail together. So you have two.
No, I understand the background of
Right.
how they ended up in the house, but what I'm trying to understand from you is whether or not the police have the right to go into the house to try to figure out what happened to the other two people.
Oh, the police have the
because
right
because
sorry.
that relates to whether or not they could seize these bottles.
The police had the right to go in because the judge made a factual finding that they were invited in by the defendant. The defendant tries to straitjacket this into a community caretaking. Once you find out the person's
So it's
finding-
not an emergency exception.
It was not an entry.
That we're considering. You're saying that we don't have to apply that law, that the defendant allowed everything that happened there?
No, I'm not saying that.
So,
The emergency, it's kind of, a lot of the emergency exception cases deal with entry into property. But we have the McCarthy case, which talks about seizing evidence for the purposes of determining what may be going on.
yeah, but that case, they seized something that was related to the condition of the person that they were looking at that moment.
Sure, and it was reasonable because in talking with the defendant in this evolving scene, the hospital personnel say, this is a drug overdose. And the defendant says, I haven't been feeling well. And he says, well, what did you guys all share? Well, was there anything that you all shared? And they said, well, the other tequila. We all had the tequila. And that is how they focus on the tequila.
I'm just lost at the point of your argument that the police can go into this house and do things to try to figure out what happened to these other two people.
But they were invited
I don't
in.
understand the emergency exception to apply to that
They were
situation.
invited in. The emergency exception, if you look at McCarthy, is when they seize the bottles because they have a situation they're trying to figure out that this might be something that is the problem. They were invited in. There's no claim. The defendant tried to claim, and the judge found that he invited the police in. So the police were lawfully where they could be. The judge even says, I'm not doing this on a plain view because the police, obviously the tequila was not criminality right in front of them. And I'm not arguing plain view because that's not what it was. But as the scene is evolving and they're talking with the defendant and they come to focus on this, and they've got, well, maybe this is the problem with these two people and why the defendant, you guys all drank the tequila. That's the part of the emergency exception. And then they seized the tequila bottles. At that point, they had the emergency, they had the reasonable belief that something was going on with the tequila bottle and they needed to take custody. And when they take custody of the tequila bottle, that's when you stop the reasonableness analysis.
But then you get back to Justice Duffley's point that you're putting an arbitrary end to the police officer's conduct here as far as evaluating the objective reasonableness of their conduct. It doesn't necessarily have to stop with the seizure of the bottles. And this is the point that everybody has been making. And
I think that then the office, then the justices are engaged in the leisurely retrospective analysis, which is not allowed under the rule.
But it's not retrospective, and you keep saying to us that we have to focus on the moment that it's seized.
Right.
And I take it there hasn't been any case that's like this that involves what do you do with it after it's been seized.
Right.
So the reason why the language is there, look at it the moment that it was seized, is because those are the circumstances that were presented to us in the earlier cases. But now we have a situation that seems to suggest that there's at least some implied follow-through as to how the police should treat the evidence that they seized on the emergency basis, and they must continue. It just seems logical that they have to continue to use it for the emergency purpose.
If it is, it's only a factor. It shouldn't be the overwhelming thought, the overwhelming action of the police that swallows up what they had done leading up to this. It may be a factor to consider. It's still the Commonwealth's position that when they seize it, this court has held that you look at the point of seizure to determine the reasonableness of the actions.
Can I issue a fact question? The drugs at issue were only found in one bottle, correct?
Yes, that's right, the one on the counter.
One on the counter in the kitchen.
Right, the bottle from the garage was clean.
You don't argue inevitable discovery?
No.
Okay.
Because it wasn't argued below, so I feel constrained that I can't. But again, I think the ambiguous nature of the tequila bottle, it wasn't as you said, a package of cocaine lying out on the cutting board. They had a belief that this is the culprit, and they seized it at that time. And I'm gone with it.
Okay, but I'm just trying to make sure I understand. Your statement is that it was reasonable to seize it.
Right.
Because
they had the information from the hospital that they had 2 drug overdoses. They have the dispatch saying the defendant didn't come to work today. They know that there was a party at the defendant's house the night before.
Right, no, I understand that,
Right.
but it was reasonable to seize it for what purpose?
It was reasonable to seize it so that the police could take custody. Now, what they do with it...
But that's, I guess, the core of it.
Well, and that's what this
so
court has to figure out.
You're saying it's
was it
reasonable for the police to take custody even if its purpose was not to assist in rendering emergency aid to those 2 other individuals?
I think at the time you can infer, and the judge inferred, that at the time Tynan seized it, his intent was not for evidentiary purposes. It was for emergency. Now, the fact that that did not get done does not affect his intent, as the judge found as a finding of fact at the hearing.
And is it his intent or the collective intent of the police which we look to?
I think you look at Tynan's intent. He was the officer that seized it.
But we don't usually do that in in assessing a reasonable, the individual intent of the officer doesn't.
Well, he's the actor. I guess it's his, what is his intent is the question of fact. When he seized that bottle, what was his intent? His intent was to take custody of it, to determine, I say the judge inferred, and you can infer that it was for treatment, but we don't have that on the record.
So you're saying, let's accept all you say, that was his intent, and you say it is irrelevant if his superiors say, we are going to override you, Officer whatever, Tynan, and we are going to not have its purpose be emergency assistance, but its purpose is to be purely investigative. We are to disregard the override of Officer Tynan's purpose.
Well, I think you're assuming facts, not in evidence.
Yeah, it could be that it was simply not necessary.
But they were med-flighted by the time that the bottle was collected.
Exactly.
And we don't know the reasoning why. I am handicapped, and this court is handicapped because we don't have why it was not done. We don't have the CIO's testimony
But
about why it was or wasn't taken.
Isn't it your burden?
Of course it's my
Isn't it the burden of the Commonwealth to demonstrate that the exception applies?
And again, once it's seized, that's where the Commonwealth has its burden.
And was there any instruction, any evidence that that Officer Tynan instructed the evidence officer to take it to the hospital?
There's no evidence of that, one way or the other.
I take it Tynan went to the hospital.
I believe he did, yes. And I believe Officer Everson also went to the hospital.
Was there a search warrant obtained before it was tested?
I don't know. I don't believe so.
Okay,
If there are no further, I will rest as to the Bowden instruction and no further questions. Thank you, Your Honors.
thank you.